rules. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner with over 30 years of unbroken service to the community is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340. or 077-127-61884. BWF Solicitors, your trusted legal partner.
Hello. You're once again welcome to Hanging Out with BWF Solicitors. I hope you are all doing great. My name is Victoria Newton, and I'll be taking you through this program with my guest, lawyer Eunice Achampong, who is also a partner and lawyer at BWF Solicitors. Today, we'll be talking about a married couple, what happens to a property that a married couple, own when there is a separation. Who takes the property? Do they all have equal rights to the property? Lawyer Eunice is going to delve into it. We would love to hear from you on all our social media handles, especially Facebook and YouTube at BWF Solicitors. If you prefer to contact us live in the studio, of course you can do so on 0744 8619 711. The number again is 0744 8619 711. You can also send me a WhatsApp message and I'll be able to pick that up as well. Also remember that BWF Solicitors don't only handle divorce, they are also a family law practice. They deal in immigration and nationality, Ghana law and practice, dispute resolution. So if you have any problems in regards to the law, look no further, contact BWF Solicitors. At the end of this program, Lawyer Eunice will leave her details and office address for you to contact her, if you wanted to take up your case. So I wouldn't like to waste much of your time. Quickly introduce my lovely guest, Lawyer Eunice Achampong. Hello, Lawyer Eunice.
Hi, Vicky. How are you doing?
Hey, I'm good. And you?
I'm doing really well. I'm loving your earrings. I'm actually loving it.
Oh my goodness. Now, Eunice, you put me on the spot. But anyway, thank you so much. And you also look very well. I know between the two of us, you are the one who is always under pressure with work overload and all those things. So I really, appreciate the hard work you put into helping your clients, and especially the Ghanaian community. Thank you so much. Even with that pressure and, hard work, you still, look fresh and glowing. So later we'll have to find out your secret.
It's good. It's good. I like the fact that the sun is also out, so it
Yeah.
gives us something to enjoy or go out and celebrate. So it's nice that we have this weather, and I hear that tomorrow the clocks will be moving forward for spring. So
Yes, it
that's also
is.
something to look forward
It
to.
is.
Yeah.
It is. It is. When you told me about today's topic, do you know the number of women who got in touch with me? I was surprised. I didn't get any mail contacting me in regards to this topic.
Wow.
Yes. 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 So that tells you what is going on.
Yes, of course.
So, if I may ask, why this topic today? In fact, today is a different ballgame altogether.
I know. So I've had inquiries about this before, and there was one particular person who came to see me very recently. It wasn't actually a woman, it was a man actually. And he came to see me regarding yes, this issue. And so I said to myself, let's do a topic on this because this is something that I know happens a lot within our ethnic minority. And so I said, let me delve into this topic so that at least people become aware and then they start to put things in place rather than just leave it to one person. Because sometimes when you don't know, you just do things haphazardly and you just think, okay, it can be altered and there will be no consequence. But it's not always the case. So it's better that people become more aware of it and then they put the right things in place so that later on in future they are not saying, okay, this is what I expected. And it happens very much within the community where people are not married. So I was like, a lot of people who haven't got any evidence to prove that they are married fall short in these areas because to them, nothing really ties them to the fact that they are a married couple. And so they're living together, they have children together, but they don't have anything to show that they are married. And then when it becomes an issue, they realize that, oh, I should have put my name on the document. So I wanted to really go into this topic and then really advise our community, especially those who don't have any form of documentation to show that they are married as well.
True. It's true. Yeah. Well, that's wonderful. But before we go into this topic, Lawyer Eunice will briefly give us an update for the week. Then, we just delve into the topic. So, Lawyer Eunice, what updates do you have for us for the week?
Okay, so there's quite a few. I know that Parliament has very much been talking very much about this illegal migration bill, which some of us may have seen on the news. And so they are going through the reading stages and then they will take it through to the House of Lords before it becomes law. And I think what is causing a lot of controversy is to do with the fact that now they want to make the immigration rules regarding illegal immigrants and those that come in as asylum seekers and maybe their claim is seem to be unfounded, to really experience the harshness of our migration or immigration bill. So a lot of people have been saying, so if you are illegal, then it means that you would not be able to have any rights to make any applications within the UK and all of that. And we all know that we have the Human Rights Convention as we were part of the European Union. Even though we are still not part of the European Union, we still have the Human Rights Act of 1998, which entitles UK citizens or those that are resident in the UK to still keep their human rights and then apply those when necessary. So you would see that in a lot of our um, applications that we do, especially when it comes to human rights applications, we are saying that yes, maybe the person may have been an overstayer, but we know that this person has a family, which is a spouse, or they have a child who is under 18, and we believe that they have every right to have that family life with that person. Or if the person has lived there for 20 years or more, we make that private life application on their behalf to say that they have been able to establish culture and family or social ties here in the UK, and therefore it is part of their human rights that they have formed private life here in the UK and should remain here. So, yes, if we are hearing anything in regards to this bill, and you think that um, the government is being really harsh, I know celebrities such as Gary Lineker have gotten into trouble for speaking out about it.
Exactly. Yeah.
Um, if you are a constituent and you believe this is something that you're really up for your MP to discuss or talk about in Parliament, send an email. MPs are there for you. They're available to you. And so if you think that they should also join the discussion in terms of this bill, then email them, send them a message, let them know what your point of view is and the fact that you would also want them to speak about it in Parliament so that we don't get the worst end of it by the time it becomes law. So, yes, that is something that I wanted our viewers to also bear in mind. And then,
Okay.
secondly, our immigration rules, they constantly change. And so, just last week, the government, or should I say, the Secretary of State and her ministers have introduced a new statement of change. So, a statement of change is when they are making changes to the immigration rule, they compile it together and then they bring it out as a statement of changes to the immigration rules. They've
Okay.
made quite a number of changes, but I'm just going to speak about two of them uh, today. So I know that in regards to our adult dependent relative applications, when it comes to those who are over the age of 18 or um, relatives that are dependent on us, so it could be a parent or those that are making applications for a child who is over the age of 18, this will be
Yeah.
applicable in your case. And
Mm.
they've tried to simplify the immigration rules and try to um, make it more, should I say, simple for other people to understand. So when they say dependent relative, they are talking about somebody who's over the age of 18 and somebody who is also related to the sponsor who is here in the UK. So you have to show evidence of the relationship. Um, Usually, birth certificates, which are registered within a year, will be good form of evidence. Otherwise, they would ask that you prove the relationship, and sometimes the best way to do it will be through a DNA. They can't obligate you to do a DNA, but obviously you will have to prove the relationship. So we advise that if you can't get the birth certificate, just have a DNA done to be able to show the relationship between you and that person. And then
Okay.
uh, when you say the person is dependent, they are also trying to say that the person is dependent in such a way that they may not receive the care and treatment that they would need in the country that they are from. So you in the UK are the person who would be the person to care for them. So they
Oh.
have some form of illness that um, they wouldn't be able to receive treatment back home, or they have some form of illness where there's nobody to care for them, and you would have to be the only person to care for them. Or
Right.
it could be that because your parents are so old and there's no one at home to care for them, you have to bring them here to the UK to be cared for, especially in their frail age, and
Age.
also to prove to the Home Office caseworker that you have every intention of caring for them without accessing the public purse to be able to look after that loved one. So that is one way that they have tried to um, try and simplify the adult dependent relative route as much as possible. And so when it comes to the other changes as well, I know that they've tried to simplify quite a bit of our sponsorship routes as well, just so that people have an idea that when they are making their applications, whether the employer has been able to apply for a license to be able to sponsor workers, or there's a worker who is coming here into the UK to work as a skilled worker. They have all of those changes as well. And I know that there's some who are looking to see if the fees will change in April. We wouldn't know until the 6th of April when the new tax year begins. So I know that a lot of people are thinking that they will increase the fees because of our current cost of living crisis. But I hope that they do not, because as it stands, it is quite expensive. So we're just hoping that they will keep it relatively low, as currently people are struggling. So uh, let's hope that they keep it that way. Um, when it comes to our general applications, I always say that it's always best to have a priority application done if you have the means to do it,
Okay.
because you don't want the application to be held with them for a period of over 6 months, a year, more than a year, and then you're thinking, but they should have made a decision by now. They
Yeah.
constantly will tell you that due to the Ukraine war and COVID-19 measures, they're still dealing with the case and they have not made a decision. And if you are somebody who wants to travel, or you desperately need for your card to arrive, then this is something that's going to cause you a lot of headache, because you're thinking, how do I get them to make a decision as quickly as possible? So if you do have the means to make a priority application, then I would advise that it's best that you make that application, paying for the application fee, the immigration health surcharge, and the priority service fee as well, just so that I know that people may be able to do that very quickly, because of the fact that currently, as things stand, they may have to pay for that priority service just to be able to have their peace of mind later on. So, yes, let's leave it here for the updates and then we can continue.
Right. Thank you so much, Lawyer Eunice, for the update. If you've just joined us, this is Hanging Out with BWF Solicitors. And today's topic is, can you have a share in the property when there is a separation? Are you entitled a share in a property as a couple when there's separation? And this topic will be discussed today with my learned lawyer Eunice Champong, who is a partner and also a solicitor at BWF Solicitors. We are streaming live on Facebook and YouTube. Please share when you get the link. And I will also entreat you to join in this discussion. Ask questions if you have had any experiences. I would like to hear from you. You can do so by sending your comments on our Facebook, YouTube page at BWF Solicitors or Vicky Newton, or call me live in the studio on 0744 8619711. It's 0744-8619-711, or send me a WhatsApp message on 0744-8619-711. Lawyer Eunice, now
Yes.
I want you to please take us through the process. I've just got married yesterday, and we decided to buy a property. How will I be sure that with us, coming together to buy a property, in future, should I decide, because from the, when you get married, you are not thinking of separation, divorce, but that is how life is. So when you're thinking ahead that should there be a separation, how will I know that from the onset I was able to put things in place so that when we get to that stage, there wouldn't be the technicalities that would affect me, in my
Yeah.
share
Later
in the
on.
property. So please, I've come to you for advice so that I can do the right thing from the onset. Tell me what the process and what we should put in place legally so that we wouldn't have this confusion when we decide to separate.
Okay. So usually with a married couple, I always say that it's always best to also know that you have an idea as to what your assets are. So not just with property, but
Okay.
everything else. It could be that you have accounts, a bank account together. It could also be that you have cars or a family car, and so everything regarding the family, you should have some idea. I know that sometimes it might be that because we see the male as the head of the house, and so we leave everything to the male's
Yes.
control.
Yes.
And so we don't really pay attention to any of these things because it is the role of the man to take up these things. But I think that we are now in a very not literate, but I would say that we are very transparent in the age that we're living in, because
Yeah.
nowadays a lot of things are put up on the web, or people put things up on social media just so that people are not as ignorant as they used to be.
Yeah.
So now I would say that most women who even are married, even if you don't know your account details, like I was at a friend's place, and for some reason she usually leaves everything to the husband, so she couldn't even remember her pin, so the
Wow.
husband had to write the pin to the card for her. And I said, this is because we trust our men so much that we just leave these things to their control. But it's good to just know it, not just because you thinking of separation later on, but just so that in case something should happen. For instance, somebody like the other spouse falls ill, and I have somebody who is going through this, and it's so painful, and the other spouse is in hospital and they are literally bed bound. If something like this is to happen and you haven't got a clue as to any of these things, what do you do then? Do you just say that because I left everything to the man's control, so the person who is bedbound in hospital should deal with it? No, you have
Exactly.
to be able to have knowledge about these things so that just in case of an emergency, you have the right details to give to the relevant parties so that you can get the necessary support and help, especially when it comes to insurance policies and things to do with um your properties and your car and all other things. It is important that both parties take an interest. Don't just say that it is the man's role and so you just leave it to them. It is part and parcel of you as a family. So I think that it is the duty of every couple to sort of be transparent with each other about these things so that we don't come later on to say that, oh, I don't have any idea as to A,
Yeah.
B, C, D. So when it comes to buying or purchasing a property, yes, you've come together, you want to purchase a property. what usually happens is that if the person has sufficient funds, they can buy the property outright without going to a bank to
Yeah.
get the bank to give them a mortgage. So a mortgage is you going to the bank to lend you money so that you can buy a property. But if you have the property, I mean the money outright, you go and then you purchase the property. And once you are purchasing a property, there's an owner to the property. And so the title deeds, which is the document that shows who owns the property, will show that person's name on it. And most conveyances or most lawyers that deal with property, either residential or commercial use, would tell you that the title deeds will now be transferred into your name. So they have a land title registration form. I think it's a TR1, and they register your details with the other party's details. So once those details are put on this TR1 form, you are asked to sign. So you, as a couple, you both sign on that form so that the transfer is made in both your names, so that we know that yes, both parties own this property. So once the transfer is done, the registration will be done by the registry. If no property has been bought before, usually they would obviously want to have stamp duty. But if it is not the case that you've owned the property, you don't have to pay stamp duty until you are remortgaging or buying another property or whatever the case may be. So in that sense, you know that the registry will be done in both names, and then you have a copy because the conveyance or the solicitor will give you a copy of the title deeds, which now show that you are both on the title deeds as owners or proprietors of that land. And then if there's any kind of restrictive covenants, so restrictive covenants are things that you shouldn't do on the land. And so if you happen to get a mortgage, so you went to the bank to get them to give you a loan to be able to purchase that property, usually the bank details will be put on there because they are the creditors. And if you were to in any way default on payments and you couldn't pay for the rest of the mortgage, they have every right to determine how the property will either be sold or transferred to them because you are not able to pay for it. So
Okay.
all of this will be explained to you by your conveyancer or your solicitor when the property is being purchased. So it's very important that from the very onset, you are involved with it. Go with the other parties, go and see the solicitors and make sure that you are signing the right forms, and you are making sure that you are doing all the right things to make sure that everything that is being done in regards to the mortgage or the land registry is being done in unison with yourself. So it doesn't matter whether you are a working spouse or not, your name can still be put on the
Oh,
land
okay.
title deeds. Yes.
Mm,
So there's no requirement that the person should be working. Maybe in regards to the mortgage, they would say that you need to show that you have some form of income or you're receiving regular income to be able to give you a mortgage. But when it comes to the land registry, it
okay.
does not matter whether you are working or not. Your name can be put
Oh, okay.
on the title deeds. Yeah.
Yeah. Yeah. Funny enough, I've got a queer on the, sending a question saying, how do I know I'm a joint tenant on the property title deeds?
Yes. So when it comes to finding out, I'll always say that you go to the land registry. And so you can do a search of the property and say that you want a copy of the title deed to be able to find out whether your name is on the property. So maybe you are an occupant in the house. And so you obviously are making that request to the land registry to find out if you are also a proprietor listed on the title deed. Usually, I would say that Because it's a process that some people may not find easy to do. It's always good to go to a conveyancer. So the conveyancer will help you with the searches and then give you the feedback once you receive
Okay.
land registry. Yeah.
Okay. All right. And Lawyer Eunice, if someone's name is not on the title deeds, but has contributed to the mortgage or the deposit, would they have any rights to the property?
So if, for instance, like I was explaining, your name was not put on there because you didn't sign any documents whatsoever to show that your details are on there. When we talk about your share, most people would think it is better that my name was on there. But in this case, you haven't got your name on there and you want to know, is it something that I could probably get a share in? The courts have a way of making a decision in regards to these cases. So, for
Okay.
instance, somebody who is married has rights under the Married Women's Act, or you can also use the Family Law Act of 1996. So
Okay.
these laws give them rights to either occupy the property or for the courts to make a decision in regards to that particular spouse's share in the home. Whereas with somebody who is not married, so remember that the laws are usually done to sue married couples, where their couple is not, they are not married, or let's say that there are a brother and a sister who went to buy a home and then maybe one person's name was not put on the property. How would that person then be able to ascertain what their right is to that property? What happens is that the courts have a way of usually making decisions where there isn't any written legal ownership. So they haven't got their name on their title deeds and they haven't had any agreement whatsoever as to how they would share the property. If
Okay.
it is the case that your names are not put there as joint tenants, and maybe for instance you are saying that because maybe I helped pay the deposit. So I bought, let's say, 30% of the deposit, and then my other spouse bought 70%. So on the
70%.
title deeds, we put the 30 and 70%. So we hold it as tenants in common so that we know at the end of the day how the share of the property will go if anything were to happen, but not necessarily in terms of separation, but just in case we wanted to remortgage or whatever, we know what our shares are. So in this case, if this person is saying that they haven't got their name on the title deeds and they now want to be able to know if they have a share, then I would advise that they should be able to show that they have made some form of financial contribution. So the courts have it in two ways. Either you have a resulting trust or you have a constructive trust. A resulting trust is when you can say that you contributed to the deposit of the property, and therefore automatically, because you helped in depositing that should I say deposit, you will have some form of share because you have evidence that you contributed to that. If it comes to constructive trust, it means that you are not necessarily somebody who has paid a deposit into the property, but you
Right.
have evidence that there was some form of agreement that it will be a family home, for instance, where the children can stay, and because your husband was paying the mortgage, you as a wife or a partner decided to then go ahead and pay for all the other bills, including shopping and then other things. So that in itself is some form of financial contribution because if you were not making those contributions, he wouldn't have been able to pay for the mortgage. So you as a partner will have to show evidence on your bank statements that you were making these financial contributions towards the home, whereas your other partner was also paying for the mortgage. And the courts will look at this to be able to make a decision as to what your shares and what the percentage of your share should be. And the law that helps the court to do this is called the Trust of Land and Appointment of Trustees Act. And so, with that, in short, we call it Tolata. And
Okay.
that pertains to those who are not married. So, those who have some form of trust or beneficial interest in a property, and they want to be able to have the court decide who occupies the property or who gets what share in the property. Yeah.
Okay. Laura Eunice, does this also apply to a situation where the wife, as at the time of purchasing the property, the wife's immigration status was still pending? So let's say she didn't have her her papers. Property purchased by the husband, then several years down the line, but that this lady, the wife, was the one paying the mortgage from day one.
Okay. So
So
if
now there's going to be a separation. What does
okay,
she do? What she's saying is that she was advised to convince the husband to, she wanted to divorce the husband. But the
okay,
husband is refusing to divorce her
yeah,
because of this
yeah,
issue.
yes.
So what right does she have? Because from the beginning, she didn't have a documentation. Therefore, she wasn't on the title deed.
So in terms of somebody who is in this predicament, first of all, let me advise anybody who is in this situation without immigration status. You buying a property has nothing to do with your immigration status. So
Right.
let
Right.
nobody convince you that if you haven't got right documents, you cannot be put on the title deeds. They are
Right.
two separate issues, and so do not ever think that because you haven't got immigration status, your name cannot be put on title deeds. It is not correct, and it is something that I think a lot of people do without having that knowledge.
It's
So
true.
yes, that is to point that fact out. Just because you don't have immigration status does not mean that your name cannot be put on the title deeds. So that's first thing first. Then, in terms of the fact that this lady is now in the situation where she's separated from this person, they're not yet divorced, but they have a property together, and this spouse who owns the property wouldn't allow her to obviously get a divorce because he knows that she will have a share regardless of whatever he says. So when it comes to something like this, I always say that either you say to the land registry, maybe you want to know whether your names have been put on there. If for sure you know that your name is not
It's not.
on the property whatsoever, then I will say that then go ahead and then also let the registry know that the land registry know that you also want to sever part of the title. So you want
Okay.
a restriction put on there that because you've been paying for it. So if she has evidence, because you're saying that she's been paying the mortgage since it was bought, so her bank statements will show that she's the one who's been paying the mortgage ever since it was bought. Then she can ask for that restriction to be put there that the land should not be obviously sold or purchased in any way without her knowledge because she has made those financial contributions in terms of that land. So if it's a mortgage that she was having, then of course I'm not sure whether she's paid all of it or they're still paying for the mortgage. But it's also good to also let the mortgager know that this is what it is happening, because you have paid for the mortgage ever since you started it.
Yes.
The only
Yes.
thing is that sometimes what happens is that some people are ignorant, and what they do is that they put the money in the other spouse's account to be
Okay.
able to pay for it. No. How then do we know? Unless you are saying that obviously once the money was in the account, you always transferred, put in the mortgage payments, mortgage
All
payments,
right.
mortgage
Mm.
payment. So please, um, if you are saying that you are the one paying for it, then it should
Paying
be a direct transfer to the mortgager, or you
from
are
your
saying
account.
from your account, definitely
Okay.
the
Okay.
mortgager, or you are saying that the payments that were made were always made with the
Mm.
reference
Mm.
mortgage
Mm.
payment, to be able
Payment.
to obviously be sure that this is something that you can surely say that you have a beneficial interest in. So your name is not on there, but you do have a beneficial interest by way of constructive trust,
Okay.
as I
Okay.
mentioned before. So
Okay.
yes, please, if she is in that predicament and she does have the evidence to show that over the years this is her contribution that she has made, then she can apply to the court for the severance of the tenancy, in terms of the fact that she has made these contributions to the property, and the evidence is clear that over the years she has been the one paying for the mortgage and not the other party. Yeah.
So in that case, can she still claim for a share in the property because the husband
Yeah,
doesn't want to divorce
definitely.
her?
Definitely.
Okay.
So she's saying that she doesn't want to be in the marriage
Yeah.
whatsoever. Then of course they can apply. She can apply for the court to
Okay.
decide
Okay.
in terms of
All
her
right.
share. Yeah.
Okay. All right. Okay. Brilliant. So, Lawyer Eunice, is it possible to have one's name put on the title deeds even after separation?
So usually what happens is that once you've separated, and I always say that if you're living on the property, is good to be able to then let the other party know that you want to know if your name or your details are on the property document. Because
Okay.
if there is any change to be made, the proprietor or the owner has to be informed. It
Mm.
cannot be made without their knowledge. So, if you are saying that now that you are separated, you want your details to be put on there, it might be difficult if the other person is disputing it. So, you're saying that, okay, this person um, registered the house in my name,
Mm.
and they now don't obviously want to include the other spouse's details on there. It might
Right.
be very tricky, because unfortunately you cannot make any changes to um, the title deeds without the consent of the property owner, or should I say uh, the person who is named as proprietor. So it's
Okay.
important that the two of you come to an agreement. And if it is the case that um, the two of you come to an agreement that maybe, if not 50-50 share, maybe 40-60-30, and if the both of you agree, then yes, you can do so. You can have the title deeds amended to show that this is your share and that is the other person's share in terms of the title deeds. And so it can be amended if the other party
Okay.
consents. Yeah.
All right. Okay. Laura Eunice, I have to, I know the answer, but for the benefit of those watching us, why is it that there is this common thing happening when the wife calls the police reporting that the husband is abusing her, physical
mm,
abuse. And
mm,
when they get to the property, the husband is kicked out. Most
mm.
cases realize that the wife is given, the authority to live in the property with the children, and the husband would have to go and look for somewhere else. By the
Else.
time you
Yeah.
the wife and the children have been given the property, and the man will have to look for another accommodation. Please, can you, explain to
Mm.
us what happens? Was there nothing in place in regards to title deeds? Was there nothing apart from her reporting of abuse? Why
Mm.
should this happen? I know by asking the husband or partner to live somewhere else is because they want the wife and the children to be safe. But for
Mm.
that
Mm.
period of time, you realize that the man is not allowed back. And in the
Mm.
end, he has to, look for somewhere else.
Well, I will explain it in two ways.
Okay.
So, first of all, it depends on whether the property is owned or is rented.
All right.
So, if, for instance, they're living in a property that is rented, and for one reason or the other, there has been some form of domestic abuse, as you've just
Mm,
mentioned, and then they've charged the other party, for instance, then obviously, if it is something that it has become uh, uh, an offense where this person has to now be convicted of that offense, then there's
yeah.
no way that person is going to come back to the property because he's been convicted. Either he's given a non-custodial sentence or he's given a custodial
Right.
sentence, depending on the abuse that took place.
Mhm.
If it is the case that the property obviously is one that is either owned or rented, the other party can apply to the court for a non-molestation and an occupation order. So when you
Okay.
apply to the court for a non-molestation and an occupation order, you are saying to the court that this person has abused me, and therefore I do not want this person anywhere near the property or anywhere near the children. And usually these orders last for a year or two. And so what happens is that once this order has been granted by the court, the other
Mhm.
party is served this order, and therefore they cannot come anywhere near the property one way or the other until the time has lapsed in terms of the court order. And so it is the case that the other party can also make an application to the court regarding who remains on the property and who doesn't. So it's not necessarily because maybe the man hasn't got a share, but it's because
Okay.
the other party has gone to the court for the court to grant an order that they do not enter the property or
So
come.
that decision overrides you owning the property or a part owner.
Yes, because once a court order is in place to show that you cannot come near the property, it is
Mm.
only for that limited period of time. And what happens is that once it's running out, I know some people will go back to the court and say it is still
Yeah,
continuing.
be
And
extended. Yeah.
yes, so they will ask for the court order to be extended or for another one to be granted. So yes, that is usually what happens if for any reason the other party has a share and they cannot even enter. It is one of the safest ways to protect, shall I say, the family, especially
Okay.
if there is abuse going on, because you don't want the person who is abusing you or the children to come and do it again. So you would go to the court to have a court order given, unless you are saying that this person did it and they have charged him and you are okay with them convicting him of whatever charge he has been.
So, Lawyer Eunice, in the end,
Yeah.
let's say this had gone on for maybe 4 or 5 years, definitely it
Mm,
will come to a point that a decision has to be made that, what, I don't want to live in this property with
mm,
my, my wife and kids. I want to
yeah.
move on. So I need my share in the property so that I can also get my own property? At what point can this happen so
So,
that he can get on with his life?
so if there's a court order saying that you can't come near the property, that doesn't mean to say that you don't have any rights in terms
Right.
of your beneficial interest. So even though, yes, there's an occupation order in place to say that this person occupies the place, it
Yeah.
doesn't negate the fact that the other party has a beneficial interest in that property. So
Mm.
if the other party is saying that, "Do you know what, I'm a bit tight, I can't keep renting other places and
Yes.
not have a place of my own," then of course he can say that because his name is on the title deeds, he wants his share to be given to
Okay.
him. So it could be that the person living on the property now is paying the mortgage, or the mortgage has been paid off in full. So if that is the case, maybe he would want to say that I want my share to remortgage another property in the future. So he can go off and then have his the joint tenancy severed. So usually there's a land registry form that you fill to sever
Mm. Mm.
the joint tenancy, and then you basically have your share um, taken off. And then if you want a remortgage, you then have to speak to the mortgages to be able to come to an agreement and obviously purchase the next property. So for
The next.
me, yeah, it's not a big deal in terms of you having your share given to you in terms of your remortgage or whatever it is. Um, just because you're not living on the property does not mean that your share cannot be severed in terms of um,
But
the.
that has to be an agreement to your partner or wife. You can't do
So
it.
yeah, usually they have to serve it on
Need
the other
consent.
party that you are
Yeah.
severing
Yeah.
your
Yeah.
tenancy.
Yeah. Yeah.
So
Yeah.
they will have to obviously realize that you are severing your part of the tenancy. So if the other party who is living in the property says that okay, they can go ahead and keep paying for the mortgage, then of course, some people would not want to pay for the mortgage. So then they will go to the court and say, this person is severing the joint tenancy and I don't have the means to pay for the mortgage because they were the ones who were always paying for the mortgage. Then the court has to then come in and basically agree with both parties that the other person may have to continue paying for the mortgage until maybe the children are old enough. But obviously, if the home is not a home to any children, then the court will be looking at the intention of the parties when they bought the property
Mm-hmm.
and
Mm-hmm.
what the whole course of dalliance is. If it's the case that the man was the one who paid for the deposit and has paid for the mortgage throughout,
Yeah.
and there's no children or there aren't any children who are living on the property, or the children are grown now, then it might be the case that the court may have to agree with the other party
Oh,
to
okay.
have the tenancy severed, because at the end of the day, they've been able to show without any cause of doubt that they have been able to contribute more to the property financially than the other person. Yeah.
Mm, mm, okay. So even though the man has been asked to, look for somewhere else,
Yes.
um, he's still obliged to continue paying the mortgage, even though the wife and the kids are the ones living in the property.
If it's the
Because
case that,
it's an agreement between you and the bank, so you have to continue
yes,
paying.
if it's the case that the property is still on mortgage, then
Yeah,
yes, the party who's been paying the mortgage will still have to
still
pay for
have
it.
to.
And then in terms of an occupation order, the courts can even order that the mortgage payment still be made by the other party, even though they cannot enter the property.
Okay.
Yeah.
All right. Okay. All right. Yes, I've got Nana here. Nana says, "Good afternoon, Vicky and Lawyer Eunice. I'm really enjoying this program. My partner and I bought a property 15 years ago. At the time, I was bidding for a council property. So I allowed for my partner's name alone to be put off the property title deeds. Sometime later, we wanted to buy another property, and I went to see the solicitors with copies of my payslips and bank statements and an affidavit drafted. I assumed the second property will have my name on it. We have been separated for 5 years now. Can my ex-partner have the property sold without my knowledge? And how can I find out if my name is on the title deed?
Okay, so I'm believing that this is to do with the second property, because the first property, he says that his name was not put on it at all because he was bidding
for a
for
council property.
And the number of times that I hear this, that we're on the council list, or we have a council house, so they're actually living in a council house,
Yes.
and they don't want to lose it. So the other person whose name is not the should I say council tenant will then have to have the property purchased in their name. And usually, I always say that you don't want something to come and bite you later on in the foot, because you're saying to yourself, oh yes, I want something that's free, and then later something that's good that will benefit you, you instead let that go. When it comes to situations like that, I always say, please, if you don't have anything in this world and you think that you want to make some good for your children, please choose your property over council property, because at the end of the day, I don't know if you would be able to even pay for the council property later on when they give it to you for you to own, because it also involves money. They won't allow you to buy the property from the council if you don't have the means to pay for it. And mortgages are always looking to see what your means are. So if you're not working, earning a specific amount, there's no way that any mortgager will give you a loan. And then by the time you reach a certain age, maybe getting to your 60s, and you're thinking maybe this is the time you have money, they might tell you that no, because maybe the term of mortgage is maybe 20 years. You can't, they will not trust you to make payments within that 20 years. So always think ahead when it comes to things like this. So that's by the way. In terms of this person who asked the question, when it comes to the fact that this second property, you want to know whether your name is on there, yes, please go and see a solicitor and just give your details that you were occupant in that property and you went to see a solicitor. The fact that the person mentions that they went with payslips and bank statement, I'm not sure whether their name was put on there, because usually to purchase a property, the transfer has to be done with the person's details and who the mortgager is, and then how much the deposit is, and all of that. And then obviously both parties will sign. But if they haven't signed any documents in regards to the transfer of the land, then I'm not sure their name will be on there. But they can still do a search anyway to find out if their name is on the title deed. And if it comes up that their name is not on there, then obviously it means that the other party can sell the property without their knowledge, because they own the property in their sole name. If of course it turns out that the person has their details on there as owning the part of the property, then obviously there's no way that the property can be sold without the consent of the other partner or the ex-partner. So they really need to be sure if the name is on the title deed. And if the name is not on there and they still believe that they have a beneficial interest, like the example I gave at the beginning, then it means that they will have to obviously apply to the courts to say that they have a beneficial interest in that property, either that they paid a deposit or they have made financial contributions towards the mortgage of that property, and they still do, and they have evidence on the bank statements that show that they have been making the mortgage payments, then of course they may have a case when it comes to the property being sold.
Okay. All right. Yes. Oh dear. There's another question here. It says, my ex-partner and I had a traditional marriage with family and friends, but did not have a white wedding. We have 2 properties together and bought them at a time the children were very young. The children are now over the age of 18. Can we each have 1 property, and do we have to split for both properties? Go ahead, Eunice.
Okay, so if it is the case that you both bought the properties and you're thinking about splitting it has to do with you are coming to an agreement with the other party. If you believe that the both of you are joint owners to the property, then of course, why not come to an agreement?
Okay.
It might be that when the property was being bought, both of you decided that you were buying it so that the children will have a place to stay. I know that most people will either decide to make a will or decide to purchase the property in maybe their children's names. Some people can have a parent's name and another person's name if the child is over the age of 18 and is working. So, in that case, of course, if you are saying that you are purchasing that property for the children, then the both of you can decide that the children's names be put on there as part of you leaving an inheritance to them, or you can both decide that you each take what belongs to you. Because at the end of the day, if your name is on the title deeds to say that you are joint owners, that means that it's a 50-50 split anyway. So either the both of you decide to take your 50-50 split and remortgage another property and sell this property or sell both properties. Whatever the case is, there is the chance that, of course, properties will appreciate over the years. So if you bought it for 150,000, today it will be more than the 150,000 that you bought it for.
Yes.
And so you always have the advantage of selling it and making more, or you can keep it and say that, well, both of you have decided to go for each instead of splitting the beneficial interest between the two of you. So, whatever agreements you choose to come to between the two of you, that helps. If the
Okay.
two of you cannot come to an agreement, that is when obviously one party will need to make an application to the court to be able to ascertain what should be done. So in this case, this person says that the children have now grown up. So it means they bought it with the intention that it will be a family home.
Oh.
And maybe the other property was bought just because they wanted to make an investment or something. So once the children have grown up and there isn't anything stopping the other parties from doing as they wish with it, then I think that especially where the marriage has broken down so badly or the relationship ended so badly, it might be the case that you wouldn't want the property in both names. So if you want the property transferred to any of the children, you can do so immediately, or you can wait till the children are old enough and you put it in your will so that
Okay.
they will decide between the two of them who gets what. But remember that when it comes to couples that are not married and own the property jointly, once let's say that the other person dies, then it means that their share is just left there, because most married couple, if the other person dies, automatically it is just transferred to the other person. So
The
if
person.
it was that 50-50 split, automatically when one person dies, the 100% goes to the surviving spouse. Whereas
Spouse.
for those that are not married, the the beneficial interest doesn't go anywhere unless they have willed it, or unless they have asked for something else to be done with their share of
Mm.
the property. So it's very important to have things put in place, especially if you are not a married couple. Because I know that some people will say, "Oh, I've done the traditional," but
Mm.
is there any document to show that you were married? Because most people's understanding of traditional, especially within our culture in the UK, is that
Mm-hmm.
the families came together, we had a celebration, and there was a
Yeah.
ceremony that took place. But in that sense, yes, we will say that yes, there's a engagement that has taken place. It may not necessarily be that you've had it registered. So if you want to know for sure that this thing that you've done, saying that families have come together to celebrate your union between you and your partner, then I think that it is best to also have it registered. We do register customary marriages in Ghana. So if you are both of Ghanaian heritage, then you can go and have it registered. Otherwise, it's best that I think it's best that you go to the registry here in the UK and then have your marriage registered, so that at the end of the day you are sure that if anything were to happen, automatically it will uh, be something that you'll be able to do something about, because you are both married. But where you are not married and there is no document to show that you were indeed the spouse to this person, then I would say it is best to either have a will done, or the both of you agree as to what should be done to the properties, whether it's sold or you remortgage with the shares that you have. And then that way you know that you are putting things in place. Yeah.
Okay. All right. Laura Eunice, finally, how would you know if you have the suspicion that your partner has other properties that he hasn't, declared to you, but you are suspecting?
Mm.
How do you go about making sure that it is true that he's got other properties that you are not aware of, especially when it comes to separation and divorce?
Okay, so I like the fact that you said when you have a husband, because obviously the laws protect spouses when it comes to issues like this. If you were not married and obviously the other partner owned certain properties, then of course don't even think about it, because there is nothing you'll be able to do regarding those other properties, because
My
there's
property, my choice.
Of course, of course. So you
Mm,
wouldn't have any say in it whatsoever, because you were
right.
not married to this person in the first place.
Mm,
If it is the case that you are married to this person and you know that this person has other properties, but you
yeah.
don't think that your name is on there, of course, it can be in their name. The thing with married couples and separation, or having divorce, is that once you apply to the courts to say that you obviously want your share in the financial assets that have been acquired during the marriage, then both parties will have to declare what it is they have. So if you suspect that they have certain lands, you can say to the court, I my suspicion is that they have lands here, here, and there.
Mm,
And they will have to disclose that they also have the lands as you have said it. If they choose not to disclose, then it prolongs the whole matter, because what happens is that um the court is willing for you to come to some form of informal agreement. They don't want the case to stretch so badly that at the end of the day they will ask the person who has delayed the court's time to pay the extra cost,
Extra
because
cost, yeah.
the courts don't find these things funny, or they don't take it lightly, because they
Lightly.
believe that there has to be some form of settlement. And because these cases can go on for 2 years, 3 years, 4 years, 5 years, sometimes even longer than 5 years. So they believe that it is best that the parties come to some sort of agreement when it comes to financial disputes, or any form of acquisition that you have made as a married couple during the marriage. So yes, these things will definitely have to be disclosed, because there's a form which you fill, which is a form E, to disclose that
Mm,
these are the assets you've acquired during the marriage. And if the other person is so unwilling to disclose these things, they can also be penalized by the court as well. So we have to also bear that in mind. As much as the court is there to fight your case, the longer the case is prolonged, the more the cost will be borne by the parties in the process. And if it is the case that the court deems that at the end of the case, one person should be penalized, that is when that person will have to pay for the cost. But in the time that all of this is going on, both parties will be paying for the cost themselves. So it's important
okay.
that we also bear this in mind when we are applying to the courts to make a decision in terms of these cases as well. So always seek some form of settlement between the
So,
two of you. Yes.
okay. All right. On that note, I think that's what time will permit us, Lawyer Eunice. Thank you so much. But before you leave, if you go, quickly give us a summary of what we discussed over, and also your contact details, and where our viewers can book an appointment and come and see you.
Okay. So, um, what we were discussing is mainly to do with those who have purchased the property together. It could be that you were married, it could be that you were not married at the time. And of course, you are now separated and you want to know how you can go about having your shares in the property split, or having the property sold, so that as much as possible, the both of you will be able to get something from that. If it is the case that you don't know whether your name is on the title deeds, always seek from the land registry whether
Yeah.
the title deeds are in your name, or in the other party's name, or in joint names, which is you and the other partner. If it is the case that you have your name on there, then having the share split makes it easier, because you don't have to apply to the courts or anything to be able to ascertain what your share is in the property. Where obviously the title deeds is not clear that your name is on there, but you believe that you have made financial contributions towards the mortgage or towards the household, because of the fact that you were paying for certain things within the household, and that should amount to something, then you can make an application to the court, whether you are married or unmarried, for the court
Okay.
to then ascertain what your share is within the property. So it's very, very important that we bear this in mind. And like I was saying, you being put on the title deeds has nothing to do with your immigration status. It has nothing to do with whether you are working or earning an income. Your
Yes.
name can be put on the title deed, regardless of whether you're working, or regardless of whether you have immigration status or not. So yes, let's bear that in mind when it comes to things like this. As Vicky said, we don't just deal with family law, we also deal with immigration issues, and we also look at some form of civil litigation matters. And our senior partner is a Ghanaian barrister who also deals with Ghana law and practice. So if you do want to come and see me or any of our lawyers, we are situated in Seven Sisters. So we are on the 4th floor of Anna House, 214 to 218 Tottenham High Road. And the postcode is N154NP. So N154NP. And to book an appointment, you can phone our telephone number, which is 0208 493 7340. So it's 0208 493 7340. And we open from Monday to Friday, 9:30 a.m. to 6 p.m. If you want to contact myself, my number is 075 35 81 3910. So 075 35 81 3910.
Thank you, Lawyer Eunice. Oh dear, I've also learned a lot from today's discussion. And I'll also take that on board and make sure that I've got everything in place. I'm not planning to, divorce or separate, but we have to make sure that everything is put in place. So
Yeah.
I'm also going to make sure that I have everything in place. So thank you so much. And I believe that a lot of people have also benefited from this discussion. If you just joined us or you joined us in the middle of this program, don't worry, we've got a recorded version on our YouTube channel at BWF Solicitors. Sit down, relax, have a cup of tea, and you can start watching from the beginning to the end. And if there's anything that you are not clear with, Lawyer Eunice has, given her details. You can give her a call, book an appointment to go and see her, and herself and her team will be very happy to help. So with this advice, I believe that all of you will make sure that when that time comes, it's not going to cause so many confusion, but everything will be done amicably and respectfully. So Lawyer Eunice, once again, thank you for taking time from your busy schedules. You were supposed to relax with your family, but you are always there for us, and we don't take that for granted. Thank you so much. Ladies and gentlemen, until then, another time, we come your way another time. Take good care of yourself. And I think tomorrow, the clock moves forward tomorrow, isn't it?
Yes, it does. It moves forward tomorrow.
Or else
this midnight.
Tomorrow. So just a warning.
Yes, please. Our clocks move forward. So I think that we should get that. I know most clocks which are automated on our phones will just automatically do that.
Or else you're going to be 1 hour late to check tomorrow.
Of course.
All right. And I also like to, send my great thanks to Uncle Ben. He's done a wonderful job. Has done so much for the community, and I believe he also groomed Eunice to be what she is today, and also extending her support to help the community. So Uncle Ben, thank you so much. And I also thank everyone at BWF Solicitors. We'll come your way another time. Thank you very much. Take care and have a lovely weekend. God bless. Bye-bye.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340. or 077 127 61884. BWF Solicitors, your trusted legal partner.